You may be seated. The court is now back in session. I noticed the National Council for Evidentiary is on his feet. You may proceed. Thank you, Mr. President. Good afternoon, Mr. President, Your Honors, and everyone in and around the courtroom. Due to my client's health issues and based on today's treating doctor's report, and as I myself met my client, he indicates that he cannot follow the proceeding fully due to his fatigue and exhaustion. He requests to waive his direct presence in today's proceeding, even from the holding cell downstairs. And that request is for this afternoon session and for the whole day tomorrow as well. This does not mean that the proceeding today or tomorrow is of any significance to him, but it is due to his health concern and that he tries to save his energy for the other proceedings in this case. I'm grateful, Your Honor. And I'd like to request that he returns to the facility. Thank you. President, upon hearing the request by Evidentiary through his defense counsel to waive his direct presence in today's proceeding as well as tomorrow's due to his health, and that he intends to save his energy so that he is able to participate in other proceedings. The Chamber would like to remind that in our previous notification regarding the hearing as a consequence of the impact of the SCC's decision for today and tomorrow, that information was relayed to all the parties through the senior officers' email that it is up to the accused themselves to participate in this kind of proceeding. As this is the right of the accused, and they may decide either to participate or not in today's and tomorrow's proceeding. For that reason, Mr. Evidentiary is granted permission to return to the ECCC detention facility. Security guards are instructed to take Evidentiary back to the detention facility. President, we would like to inform the parties that after we heard the comments and observations by various parties this morning, we examined the fifth point in our memorandum, and that we decide now to exclude their fifth point from the list, so that there is no need for all parties to respond to the fifth point. That is under paragraph 3 of the memorandum. However, in its place, we would like to seek comments from parties for the rescheduling of the witnesses on the character of the accused Khieu Samphan, as it was initially scheduled to hear it this week, starting from Wednesday, the 20th of February. However, due to the current issues before us, and that there is a need for the Chamber to issue a new decision on the scopes of case 002/01, the schedule needs to be deferred. I would like now to give the floor to Khieu Samphan's defense for them to make comments regarding the character witnesses. You may proceed.
Thank you very much indeed, Mr. President. I will be very brief, since we have just submitted a request with respect to some difficulties that arise following the possible summons of TCW 665 and TCW 673. Pardon me, I'll go a bit slower.
Please speak slower, and please make sure you identify the pseudonym for the witnesses clearly.
Excusez-moi, je vais parler.
Yes, I beg your pardon. I will speak a little bit more slowly. Our team has just submitted a written request with respect to some of the difficulties that we have identified in association with the immediate testimony of TCW 665 and TCW 673. As you yourself, Mr. President, have just recalled, the first difficulty lies in the fact that the subject of today's hearings and in anticipation of your decision following the order of the Supreme Court chamber, we are still unaware of the exact scope of the current trial. And in light of this difficulty, had it been dealt with in isolation, it wouldn't be so problematic. These do not concern exclusively character witnesses, and we have notified to the chamber a very long time ago that these two witnesses can also speak to the facts of the case and not just to our client's character. And since their testimony may address some factual allegations as well as facts regarding his character, we believe that the trial chamber would be well advised to deal with both aspects of their testimony, that is, to hear what they have to say with respect to the facts and our client's character. And it is only when the trial chamber will have rendered a decision with respect to the scope of this trial. It appears to us as entirely logical, since it would be somewhat nonsensical to have these witnesses appear and state what a esteemed character Mr. Kyo Song-pong is when they do not have an idea of the actual facts being adjudicated before this chamber in this particular trial. This is why we would respectively submit that the possible testimonies of these two witnesses be postponed, and that they also may be permitted to speak to the factual allegations of this case. Thank you very much.
Thank you, Counsel. The co-prosecutors, do you have any comments regarding the response by the defense team regarding this matter?
Thank you, Mr. President. Good afternoon. We do have a response. We received a copy of this motion in French late on Friday afternoon, but have reviewed it. It is our position that there is really no reason for the trial chamber to defer character witnesses or people who are at a minimum primarily character witnesses pending the court's decision on the scope of crimes that will be tried in case 002. Frankly, we do not see how the issues that these witnesses would testify to would in any way be affected by the trial chamber's decision. The court has made clear before that the parties need to be prepared to deal with all case 2 issues. As we sit here right now, and the same was true before this decision, Kyu Sempan faces charges from the entire scope of the case 2 indictment. That was true before, that remains true now. The factual matters that have been introduced regarding the accused and their role during this trial, as the court knows, were intended to provide a foundation for the entire case 2 indictment, not just the part relating to forced movement. We were trying establishing facts regarding how the Democratic Kampuchea regime worked, what the various entities were, and what the role of each accused was, to establish a foundation, this was the word the court used, that would support trial of all the charges. Given these considerations, we have a hard time seeing how Kyu Sempan's character in any way changes based on whether S-21 is or is not added into this trial. And I recognize counsel is now saying that these witnesses may also testify to some facts, and that is fine. Part of the motion that was filed expressed a concern that we may object if they attempted to introduce evidence other than character evidence or introduce evidence as to other parts of case 002. I can give you the assurance that we would not make any such objections. I do not think that the scope of crimes that are included in this trial will have any effect, any significant effect on witness testimony from witnesses who are primarily speaking to the character of the accused. So it would be our proposition that the trial chamber go forward with these witnesses if, and I stress if, based on subsequent decisions of this court, there were new issues raised which the defense then realized that any of these witnesses have information. They can always make a motion to this court based on that. But I think that is highly unlikely. These are people who will speak to general facts about Kyu Sempan. They are unlikely to be people who will speak to specific crime sites in case 002. So for that reason, we would ask the court to continue and to go forward with the character witnesses as scheduled.
Monsieur le Président, juste une...
Mr. President, a very brief comment in response to the co-prosecutor's observations. I would just like to know what is his source of information, because these two proposed witnesses have never been heard by the co-investigating judges. So where exactly is he drawing his information from? It would be even more absurd to hear what these people have to say on the facts when we have yet to define the scope of this trial.
President Judge Lavange, you may take the floor. Thank you.
Oui, merci, Monsieur le Président.
Thank you, Mr. President. This afternoon, we will have a first clarification with respect to the scope of testimony that we had intended to hear this week. These witnesses had been labeled as character witnesses. And yet, from what I gather, I think everyone would agree that these witnesses may also have questions put to them concerning the facts contained in the closing order and relative to all three accused. One of these witnesses, as I will remind you, was very close to one of the accused persons and is very likely to bring forward useful information to relevant questions regarding the two other accused. This is of great significance, as this week it is likely to be difficult to ensure the in-court participation of Mr. Nunchia, and I believe that the defense for Nunchia would be able to comment on that. Mr. Co-Prosecutor, the Chamber has understood what you have just said. We understand that you do not object to questions regarding facts to be put to these witnesses so long as they are relevant. But could you please clarify your problem with respect to characterizing these witnesses as character witnesses? These witnesses can also be can also provide information on facts, and this may change the context not only for the defense of Mr. Kyo Sompong, but also for the defense teams of the other accused persons.
Thank you, Judge Laverne. We characterize them as character witnesses because that's how they were identified as the defense. In their submissions, that is the case. I will remind the court that all parties listed witnesses, proposed witnesses for the entire case 002 trial prior to severance back in 2011. And at that same time, the Kyu Sampan defense, as all parties, filed summaries of the facts that they expected these witnesses to testify to on the entire case 002 indictment. So when counsel asks my question as to where I got the information as to what these witnesses would testify on, I got it from you, from the filing you did. And that filing does not give any reason to suggest that these witnesses would testify on facts that would cause a problem related to the scope of case 002. Now, it's the trial chamber's discretion to decide this, and it may wish to hear from the other defense as well. But my information is based on the description of the witnesses in the Kyu Sampan defense filing, and there is nothing in there to suggest that we would have a problem going forward at this time.
The President, thank you. How about the lead co-lawyers for the civil parties? Counsel Pik Ong. Thank you, Mr. President. Your Honors, we are of the opinion that the hearing of witnesses should follow the schedule indicated by the Chamber, even though there has been a proposed additional list of witnesses concerning S21. So I believe that even there might be additional witnesses, that it should not affect the decision and indication of the trial chamber. And I believe that if we stick with this indication, we will be moving forward more expeditiously. We have experienced certain delay already so far. That's why I believe that we should not change any further. Otherwise, it will lead to undue delay of this proceeding. And I am afraid that the court hearing will continue to delay, and we have to take into consideration the advancing age of the accused and the current status of health of the accused. That's why I think that we should not defer at the hearing of these two potential witnesses. Thank you. The President, thank you. How about the defense team, the other two different teams, starting from the defense team for Mr. Nguyen Chia? Do you have any comment on this?
Thank you, Mr. President. At this stage, we don't really have any comment. We are in the process of preparing a witness list, respective character witnesses. I think, if I'm correct, our deadline is coming Friday. So Friday we will file submissions which character witnesses might testify and on grounds of what facts, etc. So Friday, we will adhere to our deadline, indicating to the trial chamber which character witnesses we intend to call upon.
The President, thank you. How about the defense team for Mr. Ieng Sari? Do you have any observation on this issue? Counsel Angadam. Good morning, good afternoon, Mr. President and Your Honors. We do not have any observation on this point. The President, thank you. The President, I hand over to Judge Jean-Marc Levange. You may proceed, Judge.
Thank you, Mr. President. Just so that this be entirely clear for the Nguyen Chia defence, is it understood that the so-called character witnesses, who may also be heard on the facts, can also be asked questions about the role of Mr. Nguyen Chia? And since apparently Mr. Nguyen Chia cannot be present this week, we would like to know if the defence is intending to give its agreement for him to waive his right to attend the hearings. Moreover, questions can be asked about the role of the accused and about all of the facts contained in the closing order.
Mr. President, I think our position at this point is that we have to discuss with our client whether what is his position in respect of your questions. You've taken us by surprise in respect of this topic, so we have to get back to you tomorrow morning on this.
The President, Counsel, you may proceed.
Good afternoon, Mr. President. Good afternoon, Your Honors, and good afternoon to everyone in and around the courtroom. As I understand the practice and the jurisprudence before this court and other courts, once a witness takes a stand, essentially all is fair game that is relevant. And so, as I understand it, were one to bring in a character witness, nothing prevents the judges especially from asking any questions that may be relevant to any issue within the closing order. That's my understanding. And more or less that would go to the other parties as well, such as the prosecution of the civil parties. That's my understanding of the law, and perhaps if I'm mistaken, this is the time perhaps to be clarified on the point, to be corrected, so that anybody who does wish to provide character witnesses would know exactly the perils that confront them. Thank you.
The President, Mr. Co-Prosecutor, you may proceed.
To be short, we agree. We agree with what Mr. Carnabas has just said. Witnesses who are brought into this court, even if they're brought in identified as character witnesses, certainly can be asked questions on any relevant issue related to the case. So while I think parties make their decisions, including decisions, I assume, about whether to waive presence or not, based on the expected information that we will hear from the witness as either set out in an interview or in a description from the parties as to the facts on which the witness will testify. While that is the basis on which we make decisions about whether to call witnesses, whether to provide waivers, certainly it is true that witnesses can be questioned about any issue, even if they are called as character witnesses.
Just a clarification. I think we all agree that all relevant questions can be asked. Now, the question what is a relevant question is obviously dependent on the scope, on the determination of the scope. Currently, the whole case is open. The Supreme Court has not only dealt with the request for the couple of additional extensions by the prosecutor, it has said we are back to square one. We decide completely free, after hearing everybody, what will be heard. Now, if we agree that this is the effect of the Supreme Court decision, how can we go ahead with witnesses without knowing the scope or before the chamber has made a decision on the scope of the proceedings? And to clarify that, I think this chamber has done its best to avoid delays, but there are decisions, like the Supreme Court decisions, that necessarily lead to a delay if they are properly implemented. If somebody has a suggestion on how to avoid this, we certainly welcome it.
I think the answer to your question is, as we have done with a number of other witnesses in this case who have testified on where the entire scope of case 002 is open. We've done that with witnesses who were senior in age, and therefore the court has allowed questioning on the entire scope of case 002. We've done that with expert witnesses where the trial chamber who are coming from abroad, where the trial chamber has issued an order saying they can be questioned on the entire scope. And so it seems to me the way we would proceed is that the witness is allowed to testify on anything within the scope of case 002. Now, if this was a witness who we expected would have days of testimony on issues that probably may ultimately be severed, there may be a reason to say we should wait. But I think because it is a character witness, because it is a witness who is likely to testify to conduct of Q Sampan, which covers which is all of which is relevant when you look at the scope of the closing order. It's unlikely that these witnesses would testify about specific crimes. So I would agree with you if there was a concern that we had a witness who was going to spend half a day testifying about genocide against the Cham, then maybe we would reevaluate. But I think with character witnesses, we can fairly safely proceed, authorize questioning on the entire scope of case 002 as we've done in the past, and still finish these witnesses with reasonable diligence.
Your Honor,
Then, counsel, please proceed.
let me just disabuse counsel for the prosecution that we can just proceed as nothing is relevant. The prosecution has one approach. The defense has another. The tactical and the strategic decisions that are made by the defense on whether to propose a witness or not depend on the scope. Now we're back to square one. Therefore, once the scope is known, a defense lawyer can decide whether they want to put a witness on because they are subject to everything. Calling a witness a character witness is just a label. That's the point that Your Honor made. And the prosecution concedes that. And so if the scope is narrow, perhaps a decision will be made to put the witness on knowing that the testimony is limited to the scope. Now the testimony is unlimited to everything. So simply because a witness is called character witness, nothing prevents the trial chamber or the prosecution or the civil parties from asking questions that are relevant to the entire scope of case 002. So for that reason, it behooves the trial chamber to not hear any witnesses until we deal with this issue. And we are here in this situation because the prosecution appealed and the Supreme Court made its decision. And now we have to deal with this issue first before we can go forward.
The President, thank you. Yes, counsel, you may proceed.
Just to briefly add one point to what has just already been said by the Chamber and by my learned colleague. It's not because today the prosecutors are asking, according to them, for only the addition of S21 that your Chamber is obliged to decide that said request does correspond to the kind of representativeness that the Supreme Court requested vis-à-vis the closing order. As the bench said, for the moment, everything is back to square one, and your Chamber can decide on practically everything. It can be as wide or as narrow as it wishes. The prosecutor's request does not bind the Chamber because the severance decision has been entirely cancelled.
President, thank you. Thank you for the observation made by all parties concerning the hearing of character witnesses of Mr. Kyew Samphan. There has been a request for the delay in the scheduling order of hearing scheduled to be held next. And it is therefore important that the Chamber gets the opinion from the relevant parties. And we have to take all the viewpoints of parties into consideration in light of the decision of the Supreme Court Chamber concerning the co-prosecutor appeal of the trial chamber's decision concerning the scope of case 002/01. The chamber will have to decide on the scheduling of the hearing as soon as possible, so that the chamber can arrange all the necessary logistic and other supporting service ready, because we need the team and witness support section to take the witness to provide testimony on this hearing. And at the same time, we have to advise party accordingly on the exact schedule. Now, the chamber continue to discuss other matters, and the chamber has put this force for the parties to opine on this issue. In relation to an extension of the scope of case 002/01 still sought, the chamber wishes to know whether you wish to indicate as to how many documents, witnesses, experts, or civil parties, including recall of individuals already heard, would be required in the support of or in rebuttal of these requests. So when would be the earliest date upon which you could be prepared to tender, or if required, present these additional documents in court? So I would like to now hand over the floor to the prosecution before any other parties to these proceedings.
Thank you, Mr. President. I will respond to the questions that are raised in issue number 6 of your memorandum. First, let me address, and what I will outline for the chamber is the additional documents, witnesses that would be required under our proposal if S21 was added or included as part of the current trial. First, let me address the issue of documents. And I would start by noting that the majority of the documents from S21 are listed in 2 of our annexes. Annex 9 is a list of S21 prisoner interrogation and execution lists. Annex 10 is a list of S21 confessions. These are documents that were proposed by the prosecutors for case 002. And I would start by noting that most of these documents have already been admitted by the trial chamber. With regard to Annex 9, we identified a total of 337 prisoner lists, interrogation logs, and execution logs from S21. 297 of the 337 have already been assigned E3 numbers and admitted by the chamber, which would leave only approximately 40 further of those documents to be put before the chamber. With respect to Annex 10, there are already 308 S21 confessions that have been admitted by the trial chamber and given E3 numbers, and therefore there are approximately 150 such documents left to be put before the chamber. So the total number of documents that originated from S21 would be approximately 200, and I would note that these are the exact same types of documents that have already been considered by the chamber, argued by the parties at the hearings, and admitted by the trial chamber. So while there is some additional documents that the trial chamber would now be put before you, they are the same types of documents that have already been considered. In addition to those, I would note a couple of other areas. Without getting into the whole history, the chamber is aware that there are submissions coming up from us on witness statements and complaints that we would be tendering into evidence. If S21 is added, there would be another group of such witness statements, but it would be not a significant number compared to the total. But there would be an additional group of witness statements that might relate to S21. And I would say that there are probably a few other documents, such as some photographs and a few other miscellaneous records that we would also put before the chamber. This is something that we could do with relative speed. So if the chamber were to issue an order to add S21 to the case, you can provide a fairly short time deadline to us, 10 days to 14 days after your order, to identify any additional documents to be put before the chamber. The order also asked us about document presentations, which is slightly separate. The practice has been, after witnesses have testified on a segment of the trial, to present documents, to do a presentation of relevant documents. That is certainly something, again, that we would be prepared to do whenever the chamber wishes to schedule it. We would suggest that that is best done after any witness testimony, and we will follow the trial chamber's orders in that regard. But we will certainly be ready when and if the trial chamber commences hearings on S21 to do a presentation on documents if the trial chamber wishes to hear from us on that. The second issue asks us about the number of witnesses that we would propose to be heard. And this is an issue that has been discussed back and forth somewhat between the chamber and the parties already. And I would start by noting that this issue was first raised by the trial chamber back at our August 2012 trial management meeting. And at that time, the trial chamber issued a memorandum, which is document E218.1. It is a 3 August 2012 memorandum regarding the co-prosecutor's proposed extension of scope of trial. And in that memorandum, the trial chamber indicated, quote, and I'm quoting from paragraph 11 of that memorandum, quote, "The trial chamber is mindful to grant this proposed extension," this is referring to S21 and Chung Ek, "but in view of Kang Guk Abe's testimony to date, in addition to the totality of crime-based evidence already before the chamber in relation to these topics and admissible in consequence of the decision E96/7, the chamber is unconvinced of the need to hear further witnesses or civil parties to address crimes committed at S21 and Chung Ek." There was subsequently a presentation, a response by our office to this, in which we indicated, while we agreed that there had been much evidence already heard regarding S21, we were nonetheless of the view that it was important to hear a small number of witnesses. And our position on that remains the same. We would submit that some evidence from witnesses needs to be publicly heard in court from people who can describe the operations of the S21 prison, and that is to ensure both that in the public hearings the prosecutors have an opportunity to meet their burden of proof, and that the defense has an opportunity to contest the evidence relating to this crime site. And so while we certainly agree that there has already been much evidence heard relating to S21, we have proposed a small number of additional witnesses. And I would note here, the trial chamber makes reference to its decision E96/7 as a reason why there is no need to hear extensive testimony from witnesses on this issue. This was the decision that the trial chamber issued regarding the admissibility of statements of witnesses who do not appear in court to testify. And I would simply remind the court that while the general gist of the court's ruling was that statements that do not relate to the acts and conduct of the accused may be admissible even if the witnesses do not appear, the chamber also ruled that one of the factors to be considered in determining the admission of such statements is whether they are, quote, of a cumulative nature in that other witnesses will give or have given oral testimony of similar facts, end of quote. And this is a quote from paragraph 24 of that decision. So it is our position that in order to ensure that this cumulative requirement or concept is satisfied, the court should hear from a representative sample of witnesses relating to S21. And that is why that we have proposed, in addition to Duik himself providing additional testimony, 4 other witnesses who we believe would cover the various issues relating to S21. That would include one surviving detainee, TCCP 21, one of the interrogators at the prison, TCW 540, the cadre who was responsible for documenting prisoners, TCW 698, and the cadre who was responsible for taking prisoners to the Chung execution site, TCW 232. So our proposal would be that in addition to recalling Duik, that the trial chamber hear from these 4 witnesses. I would note here that during that same trial management conference last year, the defense were asked whether they had witnesses they wished to call relating to S21. And I would remind the court that both the Ng Suri defense and the Q Sampan defense had no witnesses to propose relating to S21. The Noon Che defense did propose a large number of witnesses, 31 in total. However, I would note 4 of the 31 are the same witnesses that I just outlined that we are proposing. Of the other 27, many of them, when the trial chamber examines the proposal, I believe it will find that many or most of these do not need to be called. The Noon Che list includes, for example, the 2 psychologists who examined Duik in case 001. It includes some people who were determined by the court in case 001 to have no connection to S21. And it includes virtually every name that the defense could come up with of people who were associated with S21. And perhaps counsel should be invited to review that list as to whether they really do need the trial chamber to rule on all these witnesses. But it is our submission that when the trial chamber does the same thing that it has done with other witness proposals, it will find that very few of these witnesses need to actually be called. The 2 more issues before matters on this. As I've already indicated, one of the reasons that we contend that S-21 can be tried relatively quickly is because there has already been a lot of evidence heard by this court. I note, of course, as we all recall, that Duch himself testified for 12 days in this courtroom. We've heard from testimony from Nuon Chea's messenger, who delivered documents between Nuon Chea and Duch. We've heard from witnesses from the Ministry of Foreign Affairs who have testified to Ieng Saree's receipt and knowledge of S-21 confessions and his role in the arrest of people, cadres arrested from there. We've heard from a number of witnesses from the zones, sectors, and districts who have testified to cadres being called to Phnom Penh and disappearing, and who have confirmed the identity of those people on S-21 prisoner lists. And we've heard from David Chandler, who's given testimony about the role of S-21 and the role of the accused in relation to S-21. So the Chamber has not only already admitted many documents relating to S-21, it's heard extensive testimony, and therefore we believe this crime site can be tried quite expeditiously. The last point I wish to make is to give our time estimates for these witnesses. And I would simply note here that the experience that we have seen in this court so far is that crime-based witnesses have been able to testify relatively quickly. We have almost already completed the list of witnesses related to the two forced movements that the trial chamber had selected to hear. And I would note that there have been a total of 18 witnesses and civil parties who have testified regarding the first and second forced movement. Their testimony was heard in a total of only 16 court days. So, as we have submitted before, we believe that the trial chamber can schedule these witnesses in a relatively short time. For example, with the two Tulpul Kray witnesses that have yet to be heard, it has been proposed that each of them testify for 1 day, and we believe that is sufficient. That would mean that the Tulpul Kray crime site, the witness testimony, would be completed in 2 days. For the S-21 witnesses, we proposed a little longer because they are admittedly a little more complex, but still we have proposed a total of 11 days for the hearing of those 4 witnesses, as well as recalling Duch. So our submission is that the submission of additional documents can be done quite quickly, that most of the documents relating to S-21 have already been admitted, and that the necessary witnesses can be heard in a fairly expeditious manner. And I hope that is responsive to the questions from number 6.
President, Defense Counsel, you may proceed.
Just one point of clarification, perhaps the prosecutors can tell us about this. We know that they have 5 witnesses, Duch plus 4. They've indicated documents from Annex 9 and 10. Are they saying now that they do not intend to propose any transcripts of testimony from 001? In other words, witnesses that they're going to try to backdoor into the case by trying to submit their transcripts. And I would like to have a definitive answer. Thank you.
I'm happy to answer that question, Mr. President. We will be addressing this issue as part of the witness statement issue. I would note that under the court's ruling, Doik himself has already testified. By far, the most significant testimony from case 001 that would be of interest here would be Doik's testimony, but also the 50-some witness statements, OCIJ interviews that he gave. When you take away those witnesses, when you take away Doik's testimony, and you take away the key witnesses that we have proposed, that would not leave very much from the Case 1 trial. Nonetheless, all of this will be addressed by us as part of our witness statement submission. So if there are any witnesses who will not testify in court, whose statements we would offer, those will be covered in the submission that we will be making regarding witness statements. And so witness statements would include, just so I'm clear, counsel, Annex 12, 13, and I believe 11 is the annex of trial transcripts. But if we are going to propose any such witness statements, it will be done at that time.
One more point of clarification. Therefore, when we're told that now it would take about 3 to 4 weeks additional time, it presupposes that the trial chamber will rule in its favor of admitting transcripts of testimony in lieu of viva voce testimony. In other words, because there's a likelihood that the defense will be asking that some of these witnesses come and give evidence. It's not a foregone conclusion that the trial chamber will automatically admit transcripts of testimony as opposed to calling the witnesses, especially if it goes to the acts and conducts of the accused. So, in any event, I'm grateful to the answer that we got. I do think that when the trial chamber is asking for witnesses, statements or transcripts of testimony of witnesses is part and parcel of that. And so perhaps if the civil party is going to address that, we want to hear concretely. Because only then you will have the true nature of what the actual time may be added to already we have projected for this case to last. Thank you.
President, the co-prosecutor, you may proceed.
Thank you, Mr. President. Very briefly, I want to make sure I'm very clear on this. We will not be proposing testimony relating to the acts and conducts of the accused from witnesses who will not testify here. That is not the purpose of the upcoming filing from us and the defense response. That will be a filing that will identify witness statements that does not relate to acts and conduct of the accused that the co-prosecutors are putting forward. By no means, the trial chamber has already ruled on this and given us a ruling on what types of witness statements may be admitted. And so we are not going to be asking the trial chamber to reconsider that ruling. Our submission will solely relate to matters not including the acts and conduct of the accused.
President, Judge Fans, Jim, take the floor, please.
Just a clarification, basically following this discussion now. You mentioned Chandler as possible evidence, but do I understand you correctly? You don't plan to recall him in this part of the trial?
That's correct, Judge Finn. When Professor Chandler testified, the testimony was allowed on the entire scope of Case 002. So he's already provided the necessary testimony that we believe is required relating to S21. And for that reason, no, we will not make any request to recall Professor Chandler.
President, thank you. The floor is now given to the lead co-lawyers for civil parties. You may proceed. Thank you, Mr. President. if the facts at S21 is included in this segment of trial, the trial chambers cannot provide a definite response as to the number of documents, the witnesses, experts, or the civil parties to the chamber. However, all the recognized civil parties related to S21 are in the number of 128. And we need about 14 days after the new decision is made by the trial chamber to make a list for your submission upon discussing with all the civil party lawyers regarding the number of the civil parties, witnesses or experts that we would have proposed. As for the hearing days for the civil parties, we may only need between 3 to 5 court days for the civil parties. If there is a case that the trial chamber decides to include the facts at S21. President, thank you. The floor is now given to Noon Chia's defense. You may proceed.
Mr. President, as indicated earlier this morning, we would like to give our submissions and any observations after consultation with our client. Many things have been said today. Many fundamental things have been said today. We need to properly discuss these submissions and observations from the prosecution and the civil parties with our client. And as a matter of fact, I do not anticipate us to be able to even give those submissions tomorrow. We have indicated earlier via email that we need the Tuesday to discuss with our client. And in order to be able to incorporate his instructions into our submissions, I think also considering the fundamental nature of today's discussion, that we are granted the possibility to give our submissions on Wednesday.
President, thank you, Counsel. The floor is now given to Ian Sari's defense if you would like to make comments regarding this topic.
Thank you, Mr. President, and good afternoon again, Your Honors. We're in the same boat, for the same situation as the Noon Chia team is. Mr. Ian Sari today was not able to follow the proceedings, even though he was downstairs. And we did not entirely know where the prosecution was going. We had an inkling what position they may take. We had mapped out 2 or 3 different options that were available to the prosecution. Be that as it may, we did meet with Mr. Ian Sari before, but we haven't been able to meet with him and discuss with him what we heard today from the prosecution. I'm not sure that he was able to follow any of the proceedings this morning, so we would need time tomorrow to meet with him, and we can go right after the Noon Chia team. We will be highly focused. We don't anticipate taking too much time, so we should be able to go through all of it within, I would say, 45 minutes. Thank you.
Thank you, Defense Counsel. The floor is now given to Kius and Pon's defense.
Monsieur le Président.
Mr. President, indeed, as I indicated this morning, even though I did not set out a specific time frame, I think it is entirely logical for all defense teams to be able to consult their respective clients in order to discuss the substance of today's hearings and to formulate a very clear position that will be very briefly presented before your Honourable Chamber. And I believe that we would be able to do so on Wednesday morning, which appears to us as the ideal moment to do so. Thank you.
President, thank you all for your comments. The time is now appropriate for a short break. We take a 20-minute break and return at 3:10. The court is now adjourned.